I appreciate everyone coming. I'm Marty Brito. I chair the Committee on Constitutional Studies. We're sponsored by the Spartanburg County Republican Party. But I like to think that we're a committee that presents the Constitution for everyone, not just Republicans or Democrats or Independents or whatever other party present it for Americans. So I want you to join me in greeting Mr. Mulvaney. We're going to ask Nicole Cobb to lead us in the invitation.
Father, we come before you. Our country was founded on you and faith and on your word. And we just ask you for mercy on our country and our state and our county. We ask you for wisdom and for knowledge, for understanding. You are the God of hope, and only you can help us. We put our faith in you and our trust in you, Father. Thank you for the Constitution that you formed this country on. And we just pray that our meeting today would bring you glory and that you would give us some fresh ideas how to help our country. We thank you for that. In Jesus' name.
Thank you. Now, County Councilman Roger Nutt is going to lead us in the pledge.
You would turn to your Artie shirt or one of the flags. I pledge
allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. I want to briefly let you know what the format's going to be today. And I got a little tiny Terry, but thank you, Mary.
I was hurrying.
I appreciate that. The format's going to have members of the Constitution Committee, Bill Conley and Dean Brown, addressing questions to Mr. Mulvaney on constitutional issues. As I said before, I'm Marty Brito, and I'm honored to chair the Committee on Constitutional Studies. It's been a lot of fun doing it, and we're looking forward to having a meeting every month in the next year where we'll have, in addition to Roger Nutt, our county councilman, who has agreed to speak at one of our meetings. We hope to have Trey Gowdy and Jeff Duncan and some of our other elected officials so that we can discuss the Constitution and the principles of the Constitution with them so we can better understand how we interpret it. And I'd like to begin by presenting my definition of the rule of law. And of course, we have the rule of law, the constitutional discussion with Congressman Mulvaney. And Paul, you can come up there if you want. I didn't know you were going to make it. Thank you. Paul Jansen, the other member of our panel and our Constitution Committee. Anyway, get back to my definition of the rule of law. Most Americans pride themselves on our nation, the principles of the United States being that we enjoy the rule of law in this country. The rule of law, in my opinion, is a government that has to obey a written document, and it restricts what the government can do. And if the government goes outside the bounds of that written document and those restrictions, then we have reverting back to the rule of man, where one person or a group of persons, whether it be a court or a president or members of the Senate or the House, have decided what's best for everyone, and the ends then justifies the means, and we're at the rule of law, the rule of man. We want to get back to the rule of law, I believe, in this country. That's what will protect us. That's what will allow us to enjoy the freedoms that we were promised here in this country. We'll have opportunity, and with opportunity comes freedoms. Well, I'd like to take a moment and ask the panel to introduce themselves, starting with Bill Conley.
My name is Bill Conley. Currently, I teach social studies at Gaffney High School. I've owned my own business. I also work for a major retail corporation for about 15 years. Thank you.
Dean Brown?
Hello, I'm Dean Brown. I'm Vice Chairman of the Republican Party here in Spartanburg County, and also I taught economics and government for 35 years, and colleges and high schools and upper country and low country both, and I currently own a media business.
And Paul Jansen?
I'm Paul Jansen. In the 1980s, I worked for the Federal Reserve Bank of Dallas doing data communications and light encryption. In the 1990s, I worked for American Airlines doing mathematical models and POAM model support. I've now inherited Bob Inglis's old Let's Talk Spartanburg forum that I hold ways once a month. It's a civic and educational / political forum.
And Congressman Mulvaney, we thank you for coming this morning. We're honored by your presence. And I'd like to ask you, do you agree with my definition of the rule of law? That it's restricted, to have the rule of law, you have to have a government restricted in what it can do.
In all fairness, I was looking at the questions when you gave your definition.
Okay.
So,
that's
we're talking about what the rule, yeah, the basic definition is
Basic
accurate. There's no
definition.
question. Basic definition is right.
You know, okay. All right, well,
That's the definition of the constitutional government.
thank you. Yes. Okay, and let's start with Bill Conley, and he'll have a question for you.
Okay. One of the big questions we have is the National Defense Act that has a lot of things that seem to be good in it, but a lot of questionable things as far as constitutionality. How do you feel about the act in general? What about the specifics that talk about indefinite detention of U.S. citizens?
And I was looking at this, I don't know who the League of American Voters is. Do you know who they are? And it's going down the list with somebody that walked in, and it says that I voted for the NDAA, HR 4310. I'm not entirely sure that's right or if that's wrong. You might have the NDAA work. I think we voted on two of them, as a matter of fact. One in 2011, one in 2012, and I'm almost certain that at least one came to the House, then went to the Senate, then came back to the House. Another one may have just gone House, Senate. So to say, anytime you deal with something like that and say you voted for or against it, it's important that you understand which version you're talking about. You talk about the first House version, you talk about the conference committee, you talk about the 2011 bill versus the 2012 bill. And remember, we don't know the numbers. There's very few bills where we know the numbers. So I don't know if HR 4310 was the 2011 or the 2012 bill. But I will tell you what happened with the NDAA, because it was a very interesting discussion. The one that I think attracted the most attention, that your question is probably based on, I believe was the 2012 Act in the spring of this year. And there was a group of us, Justin Amash is a good friend of mine. I don't know if you all know Justin. Justin is we hope very much that Justin will take up the mantle that Ron Paul is leaving behind when he retires this year in the next couple of weeks. And Justin is a good friend of mine. The group of us that sit together, by the way, for those of you who are curious how the floor works, I know I'm going into a little bit more detail, is you can sit anywhere you want to on the floor. And what has happened, you don't have assigned seats like you do down in Columbia. And what has sort of happened is that the group of young conservatives, many of whom came in 2010, have sort of gravitated right down the center aisle. So if you were sitting in the balcony at any one time, it would be myself, Jeff, Trey, Justin, Joe Walsh from Illinois, who just lost his election, and a group of about 10 or 12, Raul Labrador from Idaho, and Jeff Landry from Louisiana. And we were sitting talking, the reason I say that is we're sitting there talking amongst ourselves about the language in the NDAA that specifically dealt with detention. Keep in mind, the NDAA is probably like this, and I was glad to see there's going to be a question later on about the complexity of bills, the length of the bills. So you get a bill, the NDAA, it's like this, and it's got literally hundreds of topics in it, but we did focus in on this one. And what the law said, and I'm going to butcher this, was that nothing herein shall be deemed to change the current law of the United States. And that is what the promoters, most specifically the House Armed Services Committee, which was offering it, I believe, said was the protection that folks like Justin and myself wanted. And they said, look, you can't detain American citizens indefinitely, etc. And this bill doesn't change that. One of the criticisms of that version of the NDAA was that it would give the government the right to detain citizens indefinitely. And it was during I think the language that caused a lot of question, and rightly so, was it said during the course of hostilities. Well, in the war against terror, the global war on terror, that's actually a formal name, GWOT, there's no defined end to that. So you can make a very compelling argument that this was how you could get to permanent detention without various rights. But the argument that the promoters of the bill were making was that, well, this sentence, that nothing herein shall change current law, was the protection that folks like Justin, myself, Jeff Duncan, Trey Gowdy were interested in seeing. Of course, when you actually took a look at what the current law is, the difficulty is the current law is unsettled on the topic. I cannot remember the name of the cases. It's one of those times I wish Trey were here, because that's what he does. He remembers the case names. But there was a Supreme Court case involving the overseas detention of a citizen who was engaged in terrorism. And it left open in some of our minds the question as to how that situation was going to be handled in the future. For example, a domestic citizen here who's engaged in terrorism, because there's such a thing as domestic terrorism. So that's a long way of saying it was a gray area. And I voted against that version of the bill because it was easy to fix. And when we asked for the fix is very simple. And I used to practice law a long time ago. And you could fix things like this by saying, all the foregoing notwithstanding, under no circumstances shall a citizen of the United States be detained without due process rights. Is it a restatement of our constitutional rights? Yes. Is it arguably unnecessary? Yes. Does it hurt to put it in the bill? No. And when the folks who were proposing the bill pushed back against that language, a relatively simple and arguably innocuous fix, that sort of raises a red flag. That raises the red flag, and that's why we voted against it. I remember very specifically, by the way, that in the discussions, part of our group reached out to some of the folks who were promoting the bill and received assurances, I saw it on the floor, received assurances that that language would be in the bill at a later version, or excuse me, that would be a separate bill that would be offered later that would fix that. That is the promise that was used to attract certain people's votes, not mine, and I don't think the rest of the delegation. I've been very disappointed that that bill that was promised in that negotiation has not yet come to the floor. Now, I think a later version of the NDA did not have the same issue. I want to say the 2013 version did, but I honestly don't remember. I voted for the NDAA on occasion and against the NDAA on occasion. But that was the debate, that was the discussion, that was the issue, and that's why, in that particular circumstance, I voted against it.
Before we move on to Dean's question, and
by the way, am I the only person who's freezing cold?
it is cool.
Oh, man. We went till about 11 o'clock last night at a forum in Charlotte, and I swear it was 45 degrees at the station. I haven't warmed it up.
You're still trying to recover from that.
I am. I apologize. Go ahead.
All right. My question to follow up on that is, the Bill of Rights, and specifically as it applies to the NDAA, the Fifth Amendment prohibits the Congress from passing any legislation which would deny someone the right to jury trial. How do you square that with any kind of discussion on the bill? It would seem like right away you say, wait a minute, this violates, we can't amend the Constitution with a bill.
I think there's a fair, and I don't know if this is your point, but I think there's a fair discussion as to whether or not constitutional protections extend to non-citizens. I think the courts have determined that person is defined as anybody who's here. And again, I could be butchering this, is why I wish Trey were here, but I think I'm getting it right from my con law class from 25 years ago, that the Supreme Court, or the courts of this country, have determined that constitutional protections apply to everybody here. That even if you're not a citizen, you get certain constitutional protections. I think there's a real strong argument that we should not be applying constitutional protections to non-citizens overseas. In fact, I don't know if I saw a question here about the CISPA bill, which is one of the online sort of the monitoring bills. I hope there is a question on that. But that's what that debate turned on, was what rights do non-citizens have overseas? Again, not the exact issue of the NDAA, because we're dealing with citizens. But I think there's a healthy debate right now as to whether or not constitutional protections should be extended to non-citizens overseas. I don't think they should be.
let me just quickly, and I'm going to cover that later, but quickly point out that the Bill of Rights doesn't give us any rights. Period. It doesn't give
That is a
rights
true
to
statement.
citizens or non-citizens. The Bill of Rights restricts the authority of the Congress.
No, the Constitution restricts the rights of the Congress. The Bill of Rights does two things. The Bill of Rights articulates some of the rights that we have. It further articulates the restrictions on the federal government, the national government, and then it has the all-important catch-all at the end, which is the reminder that it's not an exhaustive list of what the rights that we have. Neither is an exhaustive list of the powers that the government lacks. It is, really, go back and look at it historically, it was designed, the way they agreed to get it done was an argument that it is an instructional document. It was designed to let the people, remind the people specifically of some of the most important rights that they had. But it was important to let everybody know it was not all the rights that they had.
We'll go on to that.
I'll do whatever.
Yeah.
We're
We're going to try to just do it. If you'd like to write them down, and we'll try to get to them.
One question that is just real short. The problem I have with a lot of that is when you have any government entity can just decide who is an enemy combatant. That it's just not described, it's not discussed. It's just if somebody decides that you are an enemy combatant for whatever reason, and you can go back to Adams and all that stuff.
Right.
Just saying, if you say something, if you're trying to organize against the American government to speak up for your rights, you can be called this, an enemy combatant, and all of a sudden, there goes your rights according to some of these bills. And the big problem I have is and what I was already and what I guess Clyburn was talking about, well, we'll just make the law and let the courts decide. So here's a guy sitting in prison waiting for the Supreme Court to get to his case while he's in prison. And if we stop, I guess our question is, how can we stop this stuff, nice word to say, from happening in the first place? Because we have, our problem is, I see it, is we have a Congress that says, we'll just do whatever we want to and let everybody else sift it out, and it's going to take however long to sift it out. We'll do whatever we want to instead of being able to stop it before it gets started saying, no, you can't do this.
That's a longer question. The first question is very specific.
Yeah.
Is how do you fix the specific circumstance of citizen versus non-combatant? And that's why that language, that one sentence, that nothing herein shall be interpreted to deny any citizen of their due process rights. That's the protection. That's easy. It should be self-evident.
Right.
But again, it doesn't limit the bill in anything. It's sort of like what the Bill of Rights said. The Bill of Rights didn't give us any rights, didn't do anything, didn't really change the Constitution. Just sort of reaffirmed what we all knew to be the case in the first place, or at least what the founders believed to be the case in the first place. So it's easy to fix in a specific circumstance. Your bigger issue, which is how do we get Congress out of the business of just passing whatever they want to pass and say, look, we'll leave it to the courts. That's a real debate within Congress. It's a debate within the parties. I go back, one of the reasons I got into this business was McCain-Feingold. I just thought this was a travesty. I was so disappointed in our own party in doing this. And I remember very vividly when George Bush signed it, someone asked, it's probably allegorical now, but the story goes, that somebody asked him, don't you think this is unconstitutional? And he said, well, but that's not my job, that's the Supreme Court's job. And that is a school of thought that really does believe that. I happen to think that's wrong. There's no reason to take a pledge to defend the Constitution if it's not your job to interpret for yourself what is unconstitutional. The President had thought that the bill was unconstitutional. He should have vetoed it and then seen if enough members of the legislature thought it was worthy of proceeding. But how do you get over that? I don't know. You could turn to the specific. Why do we do it, by the way? We do it, and I say we, and there's both, when I say we, Congress, I'm not saying I participate in this because I often fight against this, but take the health care bill, for example. The reason that the bill was passed in its fashion, essentially saying, look, we're going to punt on all the constitutional issues, and to a certain extent punt on most of the details, is that once they got into the details, they couldn't pass the bill. It would end up dividing enough people. Enough people knew what was in the bill would never have passed. To go back and use, to paraphrase Nancy, that you sort of pass these broad brushstrokes and say, oh, well, the courts will figure out the details, or the regulatory agencies will figure out the details. I think that's wrong. Again, I think some good questions in here about the simplicity of bills. I hope we do get to. But that's why they do it, that we do it. We do it so that legislation can pass. And I guess that the certain elements in the Democrat Party, I don't like to speak too broadly about the Democrats and too broadly about the Republicans, because invariably you capture folks that you don't mean to capture in that. But generally speaking, the liberal wing of the party is more than happy to let the courts sort out as much as possible. And certainly, the Obama administration, in control at the time and now in control for another 4 years, they were very happy to let the regulatory agencies sort out the details. Because they could win all sorts of battles within the regulatory process that they never could have won legislatively.
Thank you. Dean?
I'm going to ask one of my questions. From Article 1, the legislative branch, with Congress in a perpetual state of campaigning, do you think going to a 3-year term would relieve some of the pressure and increase efficiency?
No, absolutely not. In fact, I wholeheartedly oppose any changes to any of the terms. And there's a couple reasons for that. Is Jim or Lindsay going to come here this week? Yeah. Have they ever been to your meetings?
No, they have not.
There's a reason for that. And there's a reason that I'm here. This is the perpetual state of the campaign. There's nothing wrong with that. I'm here because I get elected every single 2 years. The job of the House is to stay in touch with the folks back home. The job of the Senate was different. It was set up differently for different. When the Constitution was set up, the 2-year term of the members of the U.S. House was the shortest term that anybody had ever heard of, ever, in any elected government. The 2-year term, and they did it on purpose, so that we had to continually stay in touch with folks back home. They did the Senate for a different reason, to sort of have a little bit of detachment, so that we were more responsive to the vagaries of what was going on back home, and the Senate was a little bit more insulated from what was going back home. So if it was an overreaction, it could affect the House, but not the Senate. But if it was real, it could affect the House and the Senate. So I like the 2-year terms. The thing I don't like is the money, because we spend way too much time raising money as opposed to dealing with issues and constituents. But that's not a function of the length of the term. I think that what you saw in 2010 is the way it's supposed to work. Your legislature, your government overstepped. Okay? The government did too much. The Democrats who were in control in 2008, 2009, and 2010 went too far, and the people reacted against that in a very short order. It was the largest, change in the House in several generations. That's exactly how it was supposed to work. If it had been 3-year terms, or now you're more commonly 4-year terms, we'd only now be dealing with the reaction to what Obamacare did in 2009 or something like that. And you feel it, I feel it, the energy level is already down a little bit from where it was just 2 years ago. And if you had had 4-year terms, some of that reaction would have dissipated. And I think the system that the Founding Fathers set up in that particular circumstance is spot on. It should stay the same.
Thank you. Paul?
Okay. Congressman Mulvaney, it's good to see you again. I'm glad to chat with you. This one's probably going to be a softball question for you.
I would hope they'd all be soft.
Treaty not changed.
I read that in your undergraduate days you did international relations in your college. This is on the treaty power of the Constitution, and it's a two-parter. In Article 2, Section 2, it gives the President the power, by and with the advice and consent of the Senate, to make treaties, understanding the principles of the Constitution. Can the President and the Senate use the treaty-making power to usurp the Constitution? This involves executive branch overreach, in my opinion.
Yeah, no, I think the answer is no.
Okay.
I mean, the method for amending the Constitution is set forth in the Constitution. It's not like the treaty power doesn't say, and one of the ways to amend the Constitution is via treaty. So I guess that the better, perhaps, summary is that you can, to the extent a treaty, which is passed appropriately with the President and only the Senate, is consistent with the Constitution, then it's fine. If you get to a point where the Constitution says X and the properly approved treaty says Y, the Constitution has to trump. That would be, any legal document would be read consistent with that approach.
There's there's two additional parts to this question.
Okay.
I think one of these comes before. Please discuss our option, and this is a major concern of mine also, please discuss our options if the U.S. signs a treaty with the UN to effectively change the Constitution by putting restrictions or qualifications on private gun ownership. There's been a concern that the Senate would sign away our rights by signing a treaty with the UN. My understanding is I've heard both legal arguments that when the Senate signs a treaty, it's legally binding on the United States.
We get this a lot. By the way, it's a good opportunity for me to plug the website. It's mulvaney.house.gov. It's pretty standard for every member of Congress. But we've got something on there that I don't know if a lot of other folks do, which we have sort of a fact or fiction page, bunk or debunk. So if you get the emails that we all get, because we all get a lot of the same circular emails, there's actually a thing you can go and press on that page. And we might have already heard of the email that you're sending in, and we've researched it and said it's true, it's false, it's somewhat true, it's somewhat false. Or if it's a new one, we actually have a group of kids, interns, who do the research. And then we'll add it to the list. So if you get one of the emails, go to the website, see if it's already been addressed, and if not, send it to us and we will address it. And we get this one all the time about the current discussion on the UN treaties regarding gun ownership and so forth. And all the legal research that we've done, I've talked to Trey about this at length as well. I've got a great group of lawyers in my office. It says exactly what I just told you, which you can't do that. You can't bypass the Second Amendment by passing a treaty with it. Think about it. If you could bypass the Constitution with a treaty, let's go to a balanced budget amendment in the United Nations. I mean, we can get that done, right? I mean, you just can't do it that way. It can't be that simple. It violates the basic tenets of the document itself. So I tell people, look, I do worry about a lot of things, given the last election. In fact, I worry about a lot more things now than I did a month ago. Losing my gun rights because of a UN treaty is not one of them. I'm much more worried when it comes to the Second Amendment rights about the actions at the state and local level, which is why some of the Supreme Court decisions in the last year or two have been so encouraging to me. But I do worry about registration. I worry about licensure of the stamping of the ammunition. I think that is where I think that the challenges to the Second Amendment from various grassroots organizations within the country that are opposed to the Second Amendment pose a much greater challenge to our Second Amendment rights than the UN Treaty.
Okay, and then part two would be, would the Federal Reserve Bank be abridging the treaty power of the Constitution by making deals with private or other central banks, other government entities? Now, that's probably going to be the hardball.
No, it's not, because we've thought about it, and I think the answer is no. And as much as I don't like the answer, I think that is the answer. I think if I interpret the question, is the Federal Reserve violating the Constitution by entering into private contracts with foreign nations?
I spent a lot of time last night reading the Federal Reserve Act, and I don't do lawyerese very well in the science, but that was interesting. I was trying to...
It was, and the part that I keep coming back to is in the Federal Reserve Act, which says that the Federal Reserve has the right to buy anything it wants to. That's a paraphrase, that's a layman's interpretation, but effectively they have the right to purchase any assets that it wants to. People think that the Federal Reserve only buys debt. In fact, that's the reason they think that. That's typically what they've done for the last 70 years. They'll buy debt. This question came up, by the way, not in regards to overseas treaties, but in the bailouts of various states. I got an email one time saying, are you all going to bail out California? And I said, absolutely not. But then I remember having a meeting with Bernanke when I asked him, after you take interest rates to zero, and after you announce quantitative easing, infinity, what's the next plan? He goes, well, we can add other assets to the balance sheet. And I didn't know what that meant in that sense. I know what that means in a corporate sense, but I don't know what it means when the chairman of the Federal Reserve says the Federal Reserve has the right to add whatever assets it wants to its balance sheet. So to go look at the act, they can buy anything. They can buy this table. They can buy this country club. And they can buy debt to the state of California.
But
and they can buy foreign currency.
Doesn't that infer that they could buy any treasury bills that the Egyptian government of any flavor sell?
Yes.
Okay. Do you see a problem? I mean, I see a problem with that. As far as the foreign policy and national
No, but that was your question. Your question was not that I see a problem with it. Your question was it constitutional?
Oh, well, my apologies to you.
Right.
My question now is, I see a tremendous tremendous
I see
problem.
tremendous problem. Listen, you don't have to worry about Egypt. I'm more worried about California.
Well, they're closer, but,
Yeah, the Constitution, I think, I don't see the constitutional challenge to it. I don't see anything in the Constitution. I mean, if you assume the Federal Reserve Act is constitutional, and there may be people in this room who think that it's not, but I'm pretty fair.
there's arguments both sides, and it's went for a long time.
Right, but I actually think it's been determined that it is constitutional. So for the sake of the discussion, we have to assume that it is, okay? We may think that's the wrong decision. And there's nothing wrong with thinking constitutional decisions are wrong. If we didn't challenge Supreme Court rulings, we'd still have slavery. And black people would still be less than human. That's not right. You have to continue to challenge the Supreme Court decisions that you believe are wrong. But for sake of an intellectual discussion, we have to assume the Federal Reserve Act is constitutional. And if it is, then I think the Federal Reserve has the right to buy this stuff. Do I think, with that as a background, it's time to look at limiting the Federal Reserve's ability to buy various assets? Absolutely. In fact, I think it's probably an issue that not very many people have contemplated, because you have this history of the Federal Reserve pretty much behaving itself and only buying U.S. Treasury debts. Okay? They've gone up, they've gone down, but they haven't gone out and bought that table. And not that many people know that they can buy that table. And now the simple fact that we are having a discussion, or starting to have a discussion about whether or not we'll have to bail out Illinois, Michigan, and California. And it's now come to light that even if the legislature says no, the Federal Reserve, which is truly independent and not at all accountable, can say yes and bail out California. That is a problem. And that's one of the things I think we need to look at. I used to think that the most important thing that we could do for the Federal Reserve was to get rid of the second half of the dual mandate.
Yeah.
To get rid of the full employment half of the dual mandate and let them just focus on prices, which monetary policy can impact. In fact, Bernanke will tell you himself that monetary policy cannot impact employment in the long run. It's a meaningless second. And by the way, that's Keynesian orthodoxy. All Keynesians think that. I used to think that getting rid of the full employment thing was the most important thing. Now, with California, Illinois, Michigan being where they are, I'm not wondering if limiting what tools the Federal Reserve has, specifically state debt, might be something we should look at right away.
I understand. I was amused to find that the Federal Reserve Police Force, and this probably should be question number 3, does come before me.
Yeah.
Since September 11th, has now been nationalized. It was a private police force because it was a private bank.
Yep.
And it was nationalized in December of 2001. So as a really tough question, I don't mind if you want to defer on this. Many governments have nationalized their central bank. Would that be a good idea or a bad idea? I hear from economists that that's, here in the U.S. that's a very bad idea, but I hear from economists across the pond at the Bundesbank that might be a good idea to nationalize.
Can I add one thing
Sure.
to that? I don't know if it was yesterday or early today in Europe, but the head of the European Bank wants to take off because some of the countries in Europe are having problems. They said, well, why don't we just all throw our budgets and everything in one big pile and then share it together, you know, like a church social.
That's not going to happen.
And of course, Merkel, her face was about that tall right there.
Yeah.
So saying, no.
The Treasury did a pretty good job 1870 to 1912. We became the biggest industrial power in the world.
Yeah.
And since the Fed, the value of our currencies went down 95%. We buy our underwear from China now.
Yeah.
So I think that might be
I'm not going to defer on your question, but I'll give you arguments both sides, because I haven't thought about that much. I take your question to be, should we get rid of an independent Federal Reserve Bank?
well, private, I don't like that word independent. I like the word, should we get rid of, should we nationalize the Fed or bring the functions back to Treasury? I know there's arguments both sides. I get from the Treasury.
Right, I mean, the whole reason we got rid of that in the first place was to try and isolate it from political pressure.
So it wouldn't do moral hazard, so it wouldn't give you guys the keys to the credit card.
Correct.
But now we have New York City big banks that have the keys to the credit card.
And that's why, and you go back all the way, again, for sake of discussion, where do you start that debate? You start that debate is whether or not the Federal Reserve is constitutional, or at least well advised in the beginning. The Constitution clearly doesn't say, and we're going to have a Federal Reserve. Part of the difficulty, of course, is once you start moving to fiat paper currency, how are you going to handle it? We have another discussion about whether or not you go back on the gold standard. So you've got an onion here with a lot of different pieces to it. So I guess to the extent I'm deferring, I'll defer on what I think about, because I haven't really thought about whether or not we'd be better off getting rid of it. Let's talk about something that we did do this year, which is we passed the Audit the Fed bill, which I co-sponsored and voted for. Some of what you've heard, by the way, this is where that email page is interesting, that on the website, what you heard is not true. How many people think that the Federal Reserve is not audited? Not audited.
By GAO standards.
I think it's one of the big four firms.
Hopefully it isn't Arthur Anderson.
They're audited. They're not audited to exactly the same standards as corporate America is, but they are audited by an outside body on a regular basis. I still supported the bill and will continue to support the bill simply because I think that, to your original point, is it should be private, should be less independent. I think that you're talking now about a situation where people don't realize this. The Federal Reserve is actually owned by the merchant banks. That when you have that type of institution that has that much power, y'all expect me to be able to at least keep an eye on it, more than just reading the FOMC minutes, 30 days after they take place. And I think it's incumbent upon us, the more the Federal Reserve wanted to be quiet, simply sit in its corner and watch inflation and make sure there wasn't too much inflation, there wasn't any deflation, then I don't have that much concern with it. When it starts talking now about $40 billion a month in mortgage-backed security purchases, when it talks about doing these foreign currency swaps, where effectively we're lending money to Europe, then I think that invites more oversight, and I think you have to have it. That said, there has to be a fine line there, because if you're going to have an independent Fed, do you want to be able to ask the Federal Reserve, to haul the Federal Reserve into Congress the same way you would Eric Holder? Some people would say yes, and some people would say no, not at all. And then I wonder if there isn't some balance between the two, where you can have some oversight, but you cannot haul the guy over the rock like you do with Holder, and rightly so. I mean, what we've done to Holder is we haven't even begun to deal with him yet. So I don't know if the Federal Reserve is its own thing and should be treated the same as every other agency, or differently than every other agency, or some type of blend of the two. I keep coming back to this thing, though, about the assets that it can buy, because essentially what we've done is given it carte blanche to do whatever it wants. And I don't know if that was ever the intention. When they passed the Federal Reserve Act, I don't think they said, all right, what we want the Federal Reserve to be able to do is bail out a state that's gone broke, even though the national legislature doesn't want you to do that. That would make the Federal Reserve superior to the national legislature. And I don't think that anybody would make the argument that was ever the intent.
And I think that's what it's become. Is I hear this independent bank all the time, but what has been for years has been supernatural, international bank. And I think that's in violation of the spirit of the Federal Reserve Bank.
Maybe I'm just a simple person, but how do you have a Federal Reserve Act created by the government, and then it become totally independent and not answerable to the government that created it?
Good question. No, it's a good question.
I'm just simple.
And you're not wrong, because on its face, I asked the same thing. I'm sitting there, wait a second, because the question actually came up with the Consumer Financial Protection Bureau, which is now the second independent agency, set up very similar to the Fed, funded actually in the same way that the Fed is. No, is it part of Dodd-Frank? It is, yeah, okay. It's either CFPB. And my question was, what if we don't like that? IPAB, the same way, the Independent Payment Advisory Board, no oversight from Congress. So how does Congress set up something that has no oversight over it? It can still get rid of it. That power still exists. We could repeal the Federal Reserve Act, we could repeal Obamacare, you could repeal the IPAB part of it, you could repeal Dodd-Frank. So the ultimate oversight still exists. You could still give the death penalty, but as long as it exists, these entities are going to exercise an unparalleled level of independence.
Congressman, I know we got, I don't know how much time you are going to be able to stay with us.
I have to pick up my daughter at 12, so I can stay here about 10:15. I have no idea what time.
It's about 5 minutes.
Oh, okay, let's keep going.
So we're not going to get to all the questions.
Sorry.
Yeah, well, I didn't mean to.
And, there is something that I do want to point out, since you know, we do want to discuss the principles
Right.
of the Constitution. This is a Constitution put out by the National Center for Constitutional Studies, and
I've got it.
you've got one of these?
Yeah.
And if you open it right in front of the Bill of Rights, you'll find the preamble to the Bill of Rights. Now, this is a Constitution that's put out by the Government Printing Center.
Okay?
You won't find that, the preamble to the Bill of Rights, in this document. You won't find it in our school textbooks. Bill, you won't find it. It is a part of the Constitution, and the reason that the preamble to the Bill of Rights, in my opinion, is so important is what it does. It explains the purpose.
This is where that begins the conventions of a number of the
Yes,
states?
so you got it.
I got it.
The convention of a number of the states having at the time of the adopting the Constitution expressed a desire to prevent misconstruction or abuse of its powers, that further declaratory and restrictive clauses be added. So the first 10 amendments are all declaratory restrictive. They understood when they ratified these amendments that they couldn't possibly think of everything. That's why they added the 9th and the 10th. The 10th was to say, hey, anything that we did not delegate to the federal government, we reserve to the states or the people of the state. The 10th Amendment is extremely important. And it's something that I wonder if you would start asking your colleagues, why aren't our schools, why do the constitutions that are taught in our schools not have the preamble of the Bill of Rights, which explains...
Is it on the document?
It's on the document. Y'all read it during the congressional
Right, no,
reading.
it's in the record, but if I pull up the parchment,
Mhm.
is it on that, or is it part of?
No, it's on it. It's the preamble, just like you have a preamble to the Constitution.
Yes.
It's the preamble before you get to the Bill of Rights. And you'll find it on the document, on the parchment.
It
Listen,
starts with the people.
there's some fabulous, I'm
No,
sorry?
that's the preamble to the Bill of Rights.
Oh.
I mean, the
Constitution. And again, I'm sitting there looking at the Bill of Rights, the one that we've all got. It's the parchment with the fancy language, and I don't think the preamble is on there. I think it may be in the congressional record as part of the bill, but I don't know if it was on. I don't know is the answer to the question.
Check.
Of course
Yeah, I'd be
it
happy
was.
to.
You know,
But you bring up a great point about the declaratory and restrictive clauses. Some great stories about our history, about the formation of the Bill of Rights. And something a lot of people don't realize is that we passed the Bill of Rights. It's actually a bill in the Congress. People forget it. The Bill of Rights came after the Constitution had been ratified. Okay, people say, oh, we couldn't get it ratified without the Bill of Rights. It's not true. They actually had ratified the Constitution, and the fear was that even though it had been ratified by the requisite number of states, publicly it did not have that much support. And that was the reason that Madison agreed to do it. He'd already had his Constitution ratified, and he'd fought the Anti-Federalists for years, or not years, but months, against having a Bill of Rights, and then realized that now he'd won the victory but was losing the war because it didn't have that much support. So he agreed to go ahead and do this. But there's a great story about, oh God, who was it? Elbridge Gerry? By the way, the first guy to suggest it was a South Carolinian. Pinckney wanted to have it, but he did it in a different fashion. I think it was Gerry who wanted to do it, and it was Madison, I think, who took it up. And Madison said it'd be easy to do, because I've already done it, when he wrote the Virginia Declaration, which is in my book. And there's a great story about the Bill of Rights, about how disappointed Madison and Gerry were in its final version, which is where I thought you were going about the original version of the document. They were looking at it as a way, they were against the Constitution, and they were looking at the Bill of Rights as a way to permanently sow cynicism and critique of the federal government. And they really wanted it to be something that would teach people in the future, don't trust the federal government. I think that's there anyway. In fact, I think we look at that in a certain way. But they were very disappointed with the final version of the bill. And one of the things that they wanted to have put in there that didn't make the government, didn't make the final version, was the language out of the Virginia Declaration. I'll read it to you. I'm always curious to know what our history would have been like if this Madison document had been incorporated into the final Bill of Rights. This is again, at the end of the Virginia Declaration, there's a Virginia Bill of Rights. 8 or 9 states had bills of rights at that time. It's one of the reasons that Hamilton, I think it was Hamilton, ultimately gave in, was that because was something that was now done. People expected the national constitution to have one because the state constitution had one. That no free government or the blessings of liberty can be reserved to any people but by a firm adherence to justice, moderation, temperance, frugality, and virtue, and by frequent recurrence to fundamental principles. And finally, that religion, or the duty which we owe to our Creator and the manner of discharging it, can be directed only by reason and conviction, not by force or violence. And therefore all men are equally entitled to the free exchange of religion, according to the dictates of conscience, and that it is the mutual duty of all to practice Christian forbearance, love, and charity towards each other. Imagine what it would have been like if that had made the final draft, because that's what Madison was originally talking about when he's talking about a Bill of Rights, something that set up, without a doubt, the individual as the be-all and end-all. Certainly, I think what we have does that better than any other document ever created. But you wonder what history would have been like.
Ronald Reagan once famously said, when he read the Constitution of the Union of Soviet Social Republics, it was a fantastic document. It gave their citizens every right you can think of.
There you go.
The only problem was, in Russia, the government gave the rights to the people. In the United States, the people had the rights before the government was ever formed. They didn't relinquish.
Well, look, I mean, if you want, it's a great topic. I wish we'd spend more time on it. But think about it. What was the conversation? The classic one we all know about the Bill of Rights. The part about Elbridge Gerry, the final declaration, the appeal to higher power, is sort of a sidelight. What's the classic conversation about whether or not we should have had the Bill of Rights? The classic argument against it was that once you wrote it down, it would be interpreted that those were the only ones that you had.
So they put in number 9.
Which is why they put in the 9 and the 10. But look where we are today. I mean, we ignore the 9 and the 10. And we haven't lost that battle, but certainly the Federalists, who were the ones who opposed the Bill of Rights, may have been partially right. There was a seed of truth to what they said. They had that ability to look 230 years in the future and say, look, if you write down that you've got these 6 or 7 rights, be careful, because someone in the future is going to try and spin that to where that's the only rights that you have. And certainly that argument is being made today. In fact, not only that, but you're hearing, I debated somebody on MSNBC about the First Amendment, and the term she used was stunning and noteworthy for its how wrong it was. Freedom from religion is the term that many progressives use now as the modern interpretation of the archaic language. That really what the document means is freedom from religion, not freedom of religion. So it's just interesting to me to sit back and to study the Constitution and to realize how much foresight these gentlemen had. It's just a miracle it's lasted as long as it has.
They were guided by providence.
They certainly do, and I certainly do.
Dean had a question. I know.
Yeah, but I'm ahead here, because this kind of, I was going to ask one of these other questions, but I'll ask this. Many people want the Constitution to wear like a straitjacket. My view is that it should wear like a warm robe with slippers. How do you picture it?
No, I will disagree with you on that. Since the Constitution is a limitation on federal power, then I believe it should be worn as a straitjacket. If it were a granting of rights, then it should be the warm slippers and the robe. But it is not. It is a limitation on what the government can do to us, and therefore I do believe it should be a straitjacket.
Bill?
Okay.
And I mean no offense by that. I mean, obviously reasonable people can disagree on it.
Talking about the 10th, we talk about the 10th Amendment, and we get into Obamacare, and we look at all the things, right, wrong, all of this, and talking about, since they declared it was a tax, how can the tax come out of, can a taxing bill come out of the Senate?
Yep.
Am I looking at it and wondering maybe is that not Roberts, where Roberts was trying to direct it, and nobody seems to have come back at it going, hey, this is wrong for so many reasons.
I saw that question in the stack. I'm like, thank you for asking that question, because it's one of my favorite stories.
But and the addition is, what can the states do now? We hear nullification, we hear you're not setting up, they're not going to set up these exchanges. What should the next step be? And it may be multiple steps by either the states, by courts, etc. What's your position?
Two different questions, and I know a little bit more about the former than I do about the latter, but I'll talk about both of them in turn. The first one is about if it's a tax, then how could it be constitutional, or at least effective, since it supposedly started in the Senate? And I remember Gowdy went. There was various things happening in Washington, D.C. that week, including some protests against the Health and Human Services rules that violate, in my opinion, our religious freedoms regarding what employers have to give to their employees as part of their health care program. And I was involved with that. Plus, it was budget week, okay? And at the same time, the Supreme Court was handing down its decision on Obamacare. So Gowdy and I were going 4 different ways, and Trey actually got in to hear the arguments and so forth. And I remember when the decision got handed down, and he calls me up and he says, this is what's happening. And we instantly hit on that same topic. Wait a second, if it's a tax, then it started in the Senate, and first of all, how could Justice Roberts miss that? So what's the deal? So he sat down in his office, I sat down in my office, we got our lawyers together, and here's what we found out. And it's absolutely right, and not surprisingly, Justice Roberts, who is smarter than I am, didn't miss anything. The bill started in the House. The bill started in the House as a student loan bill. Went over to the Senate, was completely gutted, or at least added on to, and became the health care bill. By the way, it's one of the reasons that the nationalization of the student loan program is part of the health care bill, because the bill that passed out of the House started as that. There's a doctrine called, I think it's the enrolled bill doctrine, or the enrolled legislation doctrine, I can't essentially say, which means that whatever, as long as it's a bill that comes from the House, it could have to do with gardening in the National Horticultural Center. As long as that started in the House, the Senate can gut it and turn it into whatever it wants to. And now it's the bill. It has to go back to the House, obviously, for approval, but that happened. If the bill starts, if that number bill starts in the House, then it starts in the House. And even though the Senate dramatically changed the bill to turn it into the health care bill, it ended up back. Keep in mind, also part of it was done through reconciliation, which is the budget process that my predecessor was in charge of, which is also a House bill. So we tried that, and it was a very deflating thing to learn, because Trey and I thought we had really saved the world, and it didn't work out that way. Regarding nullification, something I do not know as much about. Do you know, is Senator Tom Davis going to talk to y'all yet? Need to get him. He's one of the leading constitutional guys in the South Carolina Senate, one of my dearest friends. Tom and Eric Bedingfield, who is, if folks of you from Greenville County might know, Eric is not only the majority whip in the state house and a representative from southern Greenville County, he's also another one of my best friends and my deputy chief of staff. He runs the offices back here. And the 3 of us have talked about this a good bit. And here's what we found so far. Keeping in mind, we didn't start looking at this till after the election because I had other things to do. And we hoped that the election would make this discussion moot. Is that we've not yet found a case where nullification was successfully applied to a law that the Constitution, that the Supreme Court had already determined was constitutional. That in layman's terms, and I'm going to butcher this badly, so I reserve the right to come back and tell you, listen, I told you that was wrong, because again, we're in the middle of our research, that the nullification process could somewhat be, made analogous to stepping in where the Supreme Court has not done it yet, where the states take that authority upon themselves to say this is not constitutional. And again, if somebody knows more about this, send it to me, because this is a dynamic situation. But this is what Tom and Eric and I arrived at, is that you can try, and we probably should try, but we may be blazing a new trail here, and that we've not yet found any indication that this tool is available. I know there's somebody here, there's somebody on the back of their car that says endobamacare.easy.com or something like that. So somebody here must know something more about it than I do. But so far, we've not found fertile soil on which to plow. If I'm wrong about that, believe me, I'll do anything to get rid of this bill. So please let me know.
What about then, I guess, then if that's not the possibility, then what are the recourses of the states? A lot of them right now are doing that. We are not going to, pretty much the idea of we are not going to set up the exchanges. What are the steps that they can take? Because again, if it's a government mandate, then we end up, can they mandate something that's going to cost the states without giving money to the states?
Yeah, and I think they anticipated that in the bill. Again, I could butcher this part badly. It's been a long time since I've read the bill. I haven't read the bill, by the way. But you talk about struggling with legalese, goodness gracious. I think they dealt with that in the bill, which is if South Carolina refuses to set up the exchange, the bill does not contemplate a federal enforcement that comes down with the federal army and makes Nikki Haley set up the exchange. What it anticipates is a national pool to fill the gap. So that if South Carolina refuses to set up the exchange, the federal government will set up an exchange that captures any citizens of any state who are not covered by a state exchange. I think that's how that structure is set up.
Congressman, we have about 5 minutes where we have to go. If you'd like to pick a...
No, what I'd like to do is, can I give sort of the what do they call it, the lightning round?
Yes.
Affordable Care Act, I think we talked about that one. The NDAA, we talked, Patriot Act, by the way, keep in mind, and go to the website, there's some really good stuff about the Patriot Act. The stuff that we vote on the Patriot Act is not the stuff that none of us like. Okay, the stuff that, if you want to boil down the problems with the Patriot Act, I think, while we might disagree on pieces and parts of it, the one we don't like is the national security letters, which is the one where you can get warrants, searches, and seizures without prior approval. That is not the Patriot Act part that we dealt with in the course of the last Congress. We dealt with other rules that did have federal protections in place. In fact, one of the reasons I voted for it was after sitting down with Trey and learning that, for example, on the library rule, the protections afforded in the Patriot Act actually exceed the protections that we enjoy every single day against unreasonable search and seizure. So, and the Patriot Act is not everything that you've heard about it. One issue legislation, yes. But we'll never get to the point where we can read it in 15 minutes or less, because keep in mind, you don't have to read to be in Congress. Well, the question is, would you support a constitutional amendment requiring all bills be restricted to single issue short enough to be read in 15 minutes or less? You can't do the second one, because then it's effectively you're putting a requirement on serving that doesn't exist in the Constitution. Think about that. By the way, you can be in Congress and not have the right to vote for yourself. Jeff Duncan ran against somebody who could not vote for himself because he was a convicted felon. Single issue stuff is absolutely critical. We promised you we would do it as a Republican Party and we have not done it. And it's one of the biggest disappointments. You'll never get to the point where you can do a 6-page bill or a 7-page bill or an 8-page bill, because if I want to sit there and fix the dual mandate, maybe that's not the best example, because you can just do one sentence on that. But there are certain things you're going to do that are going to take longer than 5 or 6 pages. But yes, we should be doing single issues at a time. Let me run through. Yes, sir.
On the Patriot Act, what the TSA is saying now they're above congressional oversight. They're not coming to...
Who's saying that?
The TSA. They didn't come to your congressional oversight.
Okay, that's the first I've heard of that. Really, okay, that's wrong. The TSA is not above us.
Right, but they're not showing up to the congressional oversight. That's part of it.
There's a question on the TSA.
Is there? Okay, I wasn't aware of that. And again, I'm not on oversight. We need to do this again with me and Trey, because this is all his specialty, and he's fabulous at it, especially when it comes to oversight. Read the bill. Again, how do you enforce making somebody read the bill? 10th Amendment, we talked about that a little bit.
Well, I think you're talking about time-wise. Give them at least time to read the bill.
Yes. Oh, no, that wasn't the specific question, but no, that was actually, someone just discussed that we should have at least 72 hours. We get, by the way, what we have now is 3 days, okay? And what someone referred to it somewhat irreverently, but I think it strikes the point, it's the Jesus rule on 3 days, which means as long as it's before midnight on Friday, you can vote at it at 1 minute after midnight on Sunday. So it's not a 48-hour, not a 72-hour rule. It's a 3-day rule. So many are the times that a bill will get filed at 11 o'clock on Monday night, and we will vote on it at 8 o'clock on Wednesday morning. In fact, by the way, we've waived that rule a couple of different times because of, in order to prevent government shutdowns.
Congressman, I got one question.
Yeah.
When they were having the candidates were coming around the state, they were in Columbia, and they were up there with 3 people. Senator Mitt was there, the congressman from Iowa, I can't think of his name right now, and another person. Every person was asked about the Dred Scott decision of 1857. And I said to myself, wow, what a strange question.
to ask all the presidential candidates.
Yeah.
I mean, this was, Michelle Bachmann, the whole 9 yards, okay? Anyhow, after that, I says, I went and bought the book. I got a book on this thing. And I'm interested in this history stuff anyhow. And this decision was 7-2 against Dred Scott.
Right.
Now, the application of nullification goes this way, that all of the northern states, they said, we're not going down this road. We completely think this is a bad decision, so we are nullifying this. Then I read about it again with Thomas Woods in some of his books, that this nullification has been going on. That, there's a variety of different states. It's hard to imagine that the state of Massachusetts, Connecticut, Massachusetts, and Rhode Island, Governor Strong from Massachusetts was making a secret agreement with the British during the War of 1812.
Yeah, so they effectively seceded during the War of 1812.
Right. So all of these issues about secession, that one there is a good issue that had happened there. But this thing about the Dred Scott, I was amazed with this thing about how all of these states said, hey, we're not buying into this. So I think there is some history with that.
There is, and please do send me this, but my immediate reaction to that from a historical standpoint was that you never found out if the nullification really worked because the war intervened. It's not the same as saying that South Carolina nullified Obamacare and then the federal government didn't try to actually, enforce it against us. The war intervened before you could figure out if that nullification actually worked.
Are there any others you'd like to?
Oh, I'm sorry. The power of the federal courts. James Madison, do you believe that Congress has the constitutional authority and responsibility to prevent what Thomas Jefferson referred to as judicial tyranny? By following the advice of James Madison, he advises we need a remedy when even the judicial branch betrays us. This is one of the great questions. We can do an hour on this. The role of the Supreme Court is one of those things that you could sit and argue back for hours and hours, and nobody would be wrong. You could sit there and make the argument that it shouldn't be above the other branches. And make a very compelling argument that it should be. I mean, think about it. It sounds strange to say that. Say, well, what's the argument for making the Supreme Court above the legislative and the executive branch? That sounds sort of antithetical to our system. Well, what if the majority got together and said, we're going to do X, and evangelical Christians have to go to jail, okay? And that passes the House, and it passes the Senate, and the Supreme Court does not sit above those and does not have the right to rule that to be unconstitutional. At a certain point, we want the Supreme Court to be above the other, or else it can't perform its basic functions. Does that allow for the opportunity for tremendous tyranny of the Supreme Court? Absolutely it does. And maybe that's why the founders put such, that's some great language, by the way, on the men and women that were going to go on the court had to be the very, very best that we had. Not only in their civic virtue, but in their moral virtue. They were supposed to be the Platonic, the philosopher kings.
They were supposed to believe in the Constitution, but they don't.
That's right, and that's the risk that you run. That's the risk that you run. But if you sit there and you gut the Supreme Court and take away its authority, then what's your ultimate backstop? I don't know the answer to that. I don't have a position on that. But the point is, you're exposed to risks on both sides of the equation.
Everybody wants to have a bodyguard that's capable of beating up everybody except them.
That's right.
But then you don't need a bodyguard if you can beat them.
You are the bodyguard. The 18th Amendment. If Congress can pass any law, members believe in general welfare in the United States, why was it necessary to amend the Constitution before Congress could act in the case of alcohol? Great question. Great question, and something that I actually, for a completely different reason, did a great deal of research on this year. There was a minor bill, nobody knows about it, dealing with the distribution patterns of alcohol. Whether or not manufacturers had to go through distributors before they get to retailers. Completely arcane, means nothing to anybody other than people who sell alcohol. And I did a lot of research on the history of the sale of alcohol, and it seems to be, historically, probably because of our puritanical, Protestant Christian fundamental roots, alcohol has always been seen as something different than everything else. In fact, there's a really compelling interpretation of the 18th Amendment that says that alcohol is different than every other good and service. And it gives the states, by the way, the right to not allow it. Think about that. It's a legal product. It's not federally banned. but it gives the state government the right to completely ban it. You'd be hard pressed to find anything else that's treated like alcohol. It's a great, you could write papers on just how alcohol is treated. Reason for the Bill of Rights, we did that one. Nullification, we did that. Penalties for failure to uphold the oath. Ooh, nice. Should not the oath to uphold, support, and defend the Constitution take more seriously with penalties imposed on who's to blatantly violate their oath? The keyword of the question is blatantly. And the question, of course, is who's going to determine it? And, you know, and there's a question goes on about Clyburn saying thus and such. We are all charged at a certain level with our own interpretation of the Constitution. We certainly are as lawmakers. President Bush could have said, I interpret McCain-Feingold to be constitutional. I would have had a lot more respect for that than President Bush saying, I think it's unconstitutional, but that's not my job. That's a derogation of his duty, and that to me was one of the last straws. But at a certain point, I have to vote my conscience on the constitutionality. I'll give you a great example. We had a bill that came through. Remember a couple of years ago, they effectively banned, again, we're going to skip the highlights or the details, effectively banned incandescent light bulbs. Well, we tried to fix that early in the 112th Congress when I was a member, and it came back and it said the federal government shall have no right to ban incandescent light bulbs. I was cool with that. That was great. Then it went on and said, and furthermore, no state shall have the right to ban them as well. There are people in my conference, in the Republican Party, who voted for that because they think that that is a constitutional exercise of their authority. I voted against it. By the way, it got fixed, and it came back, failed, and came back, and came back. By the way, the reason we did that was because, practically speaking, if California bans them, everybody else bans them because California is such a big market that the manufacturers always tailor their stuff to California. So that's why it was there. But again, I thought it was an overreach. Were the fellow members of my party who voted for the bill wrong? I don't know. In my mind, it was unconstitutional, but I respect their opinion. That's why we have the court there to back us up at the end. The police powers, to support the principle of federalism reserved to the states, all police powers not specifically delegated to the United States. Listen, I can go farther than that. I support the principle of federalism reserved to the states, all powers, not just police powers, not specifically delegated to the United States. The treaty power, we talked about that, and that is that. Listen, I would love to do this again. For those of you, I know Trey is coming back, and I asked him yesterday, I said, is everything all right? Trey is probably my best friend in Congress. And y'all were very kind, by the way, to schedule this on a Saturday morning, on a beautiful Saturday morning, because the whole idea was that Trey and I were going to go play golf after.
We had tea time.
And y'all were great to do so. His dad invited him to a weekend together, and he says, you know, I haven't done that with my dad in 10 years. And I think he talked to you about it, and y'all were very gracious in letting him look. I know he will make it back up to you. I'm going to come when he comes back just to sit and watch him do this by himself.
Ask a few questions.
Oh yeah, absolutely. Because many other times when you sit there, you go, you know, I don't really know the question. Trey, can you help me on this one? And he does the same thing with me. But thank you for what you do. I'm going to run out now because I'm running a little bit late, and I do have to pick up my daughter she spent the night at a friend's house. And if I don't pick her up, I do, I'm in a lot of trouble. Mulvaney.house.gov. If you're studious enough on the internet and Bing something, I don't use Google anymore because my roommate in college works for Microsoft. You can actually still find my cell phone number, which I think several people in this room probably have.
But answer your email. I've been emailing you something ever since you've been in Congress. You have not answered me yet.
Which one are you using?
The TSA. Why do you think it's legal?
Which email are you using?
Your name for Congressman.
If you use the Congressman one, here's a good question. Here's what happens. Where do you live?
In Canada.
Okay. You should have received several responses then. I'm going to give you all, since you're here this morning, my personal email address, which is my name, Mick Mulvaney, MICK MULVANEY @mac.com. Okay? Now, will I respond to all your emails? Probably not. I do send them on to the kids because we've done research on all these issues. I said, please send us and such our research on those. But if you send it to me and I send it to the kids in the office, damn sure they're going to get.
I did receive answers from to your kids and all, but I got 2 different answers.
Okay, but at least they did respond.
I want answer from you, not from the kids in the office. That's my problem. That's my problem. If I ask you, I want to answer from you, not from your kids in your office.
Did you send the same question both times?
I said Facebook, email, I call. I said,
There were probably two lawyers and they gave two different answers.
That's right.
Talk to any lawyers, you know.
Did you ask the same question both times?
Yes.
Good. Send it to me and I'll break the tie. How about that?
Okay.
Okay. Thank you all very much for coming out.